The law that deals with crime is known as criminal law. So whenever anything that criminal law comes to your mind, the first thing you should thought, the first thought that should come into your mind is crime, offense. It prohibits behavior that is seen to be threatening, destructive, or otherwise harmful to the property, health, safety, or moral welfare of others, including oneself. The majority of criminal law is established through statutes, which means that it is legislated by a legislative body. People who break the law are punished and rehabilitated under criminal law. Criminal law varies by jurisdiction and differs from civil law, which focuses on dispute resolution and compensation for victims rather than punishment or rehabilitation. So what are we saying? We are saying that, law differs. For instance, it is the law that every country legislator legislates. That is the law that is being bound by them. For instance, if they say that gayism is a crime, gayism is a crime. For instance, in Nigeria, gayism is a crime, but in USA, gayism is not a crime. And any crime that is against a state, it is any crime that is against a state is a criminal. Is a criminal matter, and as a matter of fact, is a public issue. And why did they do it like that? They make it in a way that people will stop crime. The aim of the law is to reduce or to eradicate, because there's no way crime will stop. As far as I'm concerned, there's no way crime will stop in the whole world. So herein, we're still introduction of criminal law. Criminal procedure is a codified official action that authenticates the occurrence of a crime and allows the offender's punishment or rehabilitation. The criminal law is the main law governing criminal offenses. It is not found in any statutory or fend. This suggests that a good way to study criminal law is to study one law at a time. This can turn out to be difficult as the criminal law catalog has not been edited or attempt have been made. This is for USA. Since all criminal law is about crime, it may be better to investigate one crime at a time. Now, criminally prohibited acts and omissions are allowed. Many have been created directly or indirectly, and a few have been criminalized. Existing ones are expanded or contradicted in scope through judicial interpretation. The criminal code reflects the basic character and intellectual life of society in which it operates. Customary law was once widespread but rarely written. It has replaced written law. Therefore, as long as it is written, customary law remains part of the criminal law. Criminal law, as opposed to civil law, opposed to criminal law is civil law. So every law must either it is criminal or civil. That means it must be either public or private. That's what it means. The objectives of the study: to understand the historical background, nature, and origin of the criminal law, to discuss the extent to which the criminal law is homegrown or alien, and the extent to which the operative legal system conform or depart from the traditional justice jurisdictions, traditional justice administration. To appreciate the interdependence of the different criminal law, to identify problems in the criminal law and its enforcement, to demonstrate an understanding of the source of criminal law. Note, this program is run by African Law Student Association. We are not obliged to use any country legal system because it is an international program. Herein, we shall proceed by using the USA as a case study. As I stated earlier, we are using USA as a case study. Early civilization generally did not distinguish between civil law and criminal law. The first written law was drafted by Sumerian around 2100 to 250 before Christ. You are Nanu, king of New Sumeria, published in written code, and the text was discovered in UR Nano's code. But the early code of Urakajina in Lakash 23082-2360 before Christ is also known as another important early code as code of Hammurabi, which formed the core of Babylonian law. Only fragments of early Greek criminal law, such as Solom and Drago, survive. Early civilization generally did not distinguish between civil law and criminal law. The first written law was drafted by the Sumerian around 2100 to 250 before Christ. You are Namu, king of New Sumeria in Yuan, published a written code, and the text was discovered. But the early code of Urajjuna in Lagash, also known as the important code, the first sign of a modern distinction between crime and the civil affairs emerged during Norman's invasion of England. A special concept of criminal punishment, at least in Europe, was the late scholasticism of Spain. When the theological concept of divine punishment, prona eterna, which was imposed only on the spirit of guilt, was translated into canonical rights, see Castro. That's the source. First and last to the secular criminal law, development of nations proclaiming justice in courts can be clearly seen in the 18th century. The European countries began to maintain police service. From the point on, criminal law formalized an enforcement mechanism that would allow it to develop as recognizable entity. Purpose of criminal law. The first sign of modern distinction between crime and civil affairs emerged during the Normans' invasion of England. A special concept of criminal punishment, at least in Europe, was the scholasticism of Spain. When the theological concept of divine punishment, which is pone actena in Latin word, which was imposed only on the spirit of guilty, was translated into canonical rights. See Castro, that's the source. First and last to the secular criminal law, development of nations proclaiming justice in court can be clearly seen in the 18th century when European countries began to maintain police services. From the point on, criminal law formalized on enforcement mechanism that would allow it to develop as a recognizable entity. In the modern penal code on the American Law Association, you can find relief that informs you that purpose of criminal law is 1, to prohibit and punish conduct that's unjustifiable and unexcusable causes or threatens serious harm to individuals or general good. To put people under public scrutiny if the actions indicate that they are likely to commit crimes. To protect behavior that is without guilty from being labeled unlawful. To protect adequate notice of the nature of the activity that has been ruled illegal. To make meaningful distinction between significant and minor offenses. The Wolfenden Commission on Homosexual Crime and Prostitution, 1957, UK, took the view that it was included in purpose of criminal law. Maintaining public order, morals protects citizens from aggressive and harmful things and provides adequate protection against exploitation and corruption of special group, endangered group. These goals do not claim to be exhaustive and are not sufficient. For example, criminal law punishes crimes without negligence, and these crimes help improve public safety and well-being by not having their own negligence. The federal military government has issued retroactive and rigorous legislation to instill discipline, transparency, and accountability in officials. Some of them prescribe death-threatening crimes. Writers have said that there are 4 aims of criminal law. These are retributive, deterrence, which is particular or general, incapacitation, rehabilitation, and reformation. However, punishment is too used by criminal law to attain its greater goals. Yes, without punishment, I think the aim of law is defeated, because the major reason, which is 99% of people are afraid of crime, is because of the punishment. Here, like I will give an example, like here in Nigeria, I remember there was a time rape. Punishment of a rape was 7 years imprisonment, but because of the inflation or increment of the rape, it was increased to life imprisonment. Criminal goals should not be confused with goals of dispositional approach, which can vary from one convict to the next or from one occasion to the next. This criminal code, each state decide which action to describe as a crime. As of USA, please, we are using this as a case study, take notes. Therefore, every state has its own criminal law. Congress has also chosen the punished certain act by codifying federal criminal law into Title 8 of the United States Code. Criminal law varies greatly between federal, state, and the federal government. Some laws are similar to the common law or criminal law, but others, such as the New York criminal law, closely mimic the model criminal law. Codification of procedure. Congress codified federal criminal law and criminal procedure in 18th of United States Code. You can see the section 1 to 2725 dealing with crime. Here we will move to elements of criminal law. A person commits a crime if he or she has to satisfy all the elements of the crime. Crime legislation also defines the elements of crime. In general, every crime is made up of 3 components. One is the one is an act or action, which is criminal act. Second, the individual mental that is at the time of action, intention. Thirdly, the causal relationship between the behavior and effect, which is either to the causal or the outside causal. In the event of criminal charge, the government has the burden of proof to clearly substantiate every element of the crime, according to Erroneous versus Supreme Court of United States of America, 575 of USA, 2015. If the law does not provide for a particular state of mind, the court presumes intentional necessary to distinguish between illegal and innocent behavior. Types of crime. The criminal offenses generally fall into 4 categories: felony, misdemeanor, inappropriate offenses, and strict liability offenses. Each state and federal government determines the type of criminal activity under common law. There are 9 serious crimes: murder, robbery, slaughter, rape, sodomy, theft, arson, mayhem, robbery, and various crimes. Assault, illegal imprisonment, perjury, intimidation by perjury. The United States Code is much broader than the common law. However, Congress has limited authority to enact criminal law. State criminal law, such as the New York Criminal Code, is much more complex than U.S. criminal law, because authority is generally reserved in states. The New York Criminal Code provides for 9 levels of crime, from 4 mortgage fraud to terrorism, sentencing guideline. The federal and state governments have developed various guidelines for sentencing. Federal courts use federal judgment guideline, and the state courts use state judgment guideline. Take note in your exam when all this will ask you. They may ask you, the federal and state governments have developed various guidelines. What are the guidelines? You should know that the federal courts use federal judgment guideline, while the state courts use state judgment guideline. Take notes. Traditionally, when multiple parties are involved, participants fall into the following categories. One, degree principal, the person who actually committed the crime. That is the perpetrator. Criminals are not accomplices, and this section does not apply to them. Two, principal, a person who assists, advises others, or encourages a perpetrator in the actual consignment of a crime. An accomplice is an accomplice is the person that actually perpetrates and actually consign of the crime. Three, the pre-crime accessories, helping, advising, ordering, or encouraging a criminal to commit a crime without being present at the time of the crime. The accessory, front, which is considered as accomplice. Fourth, retrofit accessory. That means accessory that help. That means accessories that help prevent people who know you are a criminal from being exposed, arrested, tried, or punished. This section does not apply to accessory as they are retrospective guilty of another crime. To convict an accomplice, the prosecutor must establish the necessary criminal activity and the willfulness. This means that the prosecutor must prove that the accomplice assisted the perpetrator and that he had the necessary mental state. It is important to know that some jurisdictions allow accomplice to be prosecuted, though depending on the jurisdiction. Take notes. Regardless of the principal offender, therefore, an accomplice may be guilty of a more serious crime than he or she is. In certain jurisdictions, an accomplice can be found guilty while the suspect is acquitted. Please take notes. The aim of this study is for you to be acquainted with what criminal law is all about. Forget about the jurisdiction or the case study that is used, as it can be used as USA. It doesn't mean that it's not applicable. It's for you to have a general knowledge of what criminal law is all about. As a matter of fact, what you learn here will help you. 90% of what you learn here will help you in your criminal law in your jurisdiction, because they are all related. That is why it is called lex legis. I think it means law is law. Thank you. Then we'll move to the ex post facto. An ex post facto law retroactively punishes action. This constitutes explicitly forbid this practice in Article 10 and Article 1, Section 9 and 10. Punishments for status. The law cannot punish person for his position alone. Robinson versus Supreme Court, California, 370 USA 60 1962. You can go and read more about the case. State that the law criminalizes human status, imposes cruel, extraordinary penalty in violation of the 14th Amendment and 14th Amendment. For example, the state may not punish a person for being homeless as constituent of a status breach, but may punish homeless person for trespassing or wandering with certain actions. defense. In criminal procedure, the accused has various defense options. The following list shows some common forms of defense that individuals based on failure of evidence. A person's simplest defense in law enforcement proceedings is to claim that the prosecution has not or cannot prove the elements of the crimes. And you know, once the prosecution is unable to prove the elements of the crime, that means the prosecution is losing the case, because it is on onus of the prosecution to prove the crime that he alleged that has been committed by the defendants. Mistake. In certain situations, human error can serve as a defense. Legal mistake. A mistake regarding the impact of legal status or circumstances. Then we'll talk about mistake of the fact. Errors relating to facts in particular situation. Justification. These are full defenses. Self-defense. The use of power to protect yourself from someone else trying to harm you. That is self-defense. But self-defense has what is called limitations. There is limitations. For instance, you cannot just say you're using fair. Let me just give example. Someone just beats you, slap you, just go ahead and look for a weapon and fight. No. Self-defense is, for instance, maybe you are with a knife and someone starts slapping you or beating you, you can shoot the person in the knife. It is a self-defense. But it's just whereby you don't have anything, you start looking, going around to look. No. It is passing cool. Thank you. Then defending property. One can use force to protect one's property from the crimes that are taking place within him. Defending others. The right of a person to use appropriate force to protect a third party from the attacker attending to exert force on the property on the third party. Necessity. Sometimes referred to as the choice of evil. It defends the need for a person to do something illegal, or other ways it voids greater harm. Excuses. These are partial defenses. Duress. If another person forces him or her into illegal behavior by violence or threat of violence, that person can call the coercion, force, intoxication. Involuntary drunk. People can cause addiction as a defense against crime. Spontaneously drunk people can only protect themselves from the crime that requires a particular state of mind. Insanity. Person of unsound mind cannot form the requisite mental state and thus cannot be found guilty. All this one I just stated last are the exception to criminal law. Yeah, the exceptions, they are as a defense, what you use as your defense when you're defending your criminal matters in the courts. So here, criminal law is an aspect of public law. It relates to conduct which the state considers with disapproval and which seeks to control and / or eradicate. Criminal law involve the enforcement of particular forms of behavior. In summary, the general introduction to criminal law and its purpose. The purpose of the criminal law is one thing, whether it serves the purpose is another thing. Criminal law is an aspect of police law. It has acts, foundation on common law, and provides for mensory acts or omission, actus rules. That means the crime. These are also strict and absolute liability offenses. Guilty intent may take any of the following forms: an intent to do the actual wrong done, an intent to do an unlawful act, the unlawful act, though not actual wrong done. Thank you very much. I'm done with my lecture. Please, if there are any questions, students should ask. Thank you. God bless you.
Hello, Mr. Charles. Thank you so much for the lecture. And my question is, when the state fails to prove beyond reasonable doubt, the accused is left free. Is it that the accused person or the suspect, the person who the state is accusing for having committed a crime, is gone forever, or a case can be opened again? Hello, please, do you get me correct?
Yes, I got you correct. Yes, the person will go free. Have you forgotten that in criminal cases, it is beyond the reasonable doubt? Underline the meaning of, go and check the meaning of beyond the reasonable doubt. The balance of preponderance is civil cases.
Let me wait for you.
So my issue is that once the state fails through the state prosecution, the prosecutor fails to prove beyond reasonable doubt, are they not having that same authority to reopen, or to, if they come out with any concrete evidence that is beyond reasonable doubt, they can still pursue the case subsequently?
That's what I'm saying. What I'm saying, in effect, is that that provided that it could not be able, if the prosecution was not able to prove the case beyond reasonable doubt, no need, because as a matter of fact, the court is not a witchcraft. We cannot see beyond the reasonable. We cannot see beyond that thing. It is the evidence, and your proof will make you to win your case. So the person goes scot-free. So as a matter of, that's the reason why once you are dealing with anything, always have facts, have proof, have evidences that you present before the court in order to prove beyond, online I say beyond the reasonable doubt, not to the balance of probability like civil cases. Did you get it now? It means that in criminal case that you have to prove beyond, but in civil cases just to balance of probability for you to prove your case.
Yeah, I get it. I get it. Thank you, Lawyer Charles.
So if there's any other question, I'm waiting for the question. Thank you.
May I have a clarification on retrofit accessories? What exactly are retrofit accessories? I understand that they help prevent people who know you're a criminal, but from being exposed. I don't get it. Could you please explain that to me? Thank you.
Repeat your question, please. Hello?
Okay,
Hello?
I meant, here I am.
Okay.
I meant, could you please clarify on retrofit accessories for me, please? I understand the three
How many
other accessories.
Please, you know what you help me and do? Retro what?
Retrofit accessories.
I can't hear you. That's what I'm saying. Okay,
retrofit accessories.
Retro what?
Retrofit accessories.
No, we have many retro. We have retrofit. Okay, retrofit accessories. Okay, accessories that help prevent people who know you as a criminal from being exposed. Is it what they're saying? Hello? Hello, can you hear me? Hello? Hello?
I can hear
Hello?
you, but yeah, I can hear you. Winifred, can you please come again with the question? Or better still, can you type it for clarity's sake?
Exactly, exactly.
Okay, Lawyer Charles, I think it's in the chat box. The trophy accessories. Yeah, I think you can proceed with the answers.
Okay, I've seen it. Retrofit accessories. It is accessories that help you prevent people who you know as a criminal from being exposed. As in, what prevents you from people, because you cannot just say this person is a criminal without any evidence. Did you get it? It's accessory that helps you to prevent people who you know as a criminal from being exposed, arrested, tried, or punished. It does not apply to accessory as they are retrospectively or guilty of another. As first that now, you cannot just say, I know this person as a criminal, therefore he should be persecuted. No. You have to bring enough to it. That's why I say it must be proved beyond the reasonable doubt. Underline this reasonable doubt. It's not just something you just come and say, you've accepted. No. Hello? Did you get it? Okay. I'm waiting for more
Please, any further?
questions.
Okay. I think there are no further questions. So, Lawyer Charles, if you have any closing remarks you can give, and we bring the lecture to an end. I don't think there are any further questions.
Yeah, thank you very much, Mr. James. In absence of no question, I advise the student to read thoroughly to the handout. The handout is not that big. This handout was developed early enough when we are only having a mind of having only certificate programs. If you notice most of the last material that were developed are very bulky. So I don't see any reason someone should fail this course. It is all this last material we develop very bulky because we are planning on expansion of the programs. So I advise anyone to read the material very well, and we promise that none of the exam question will come out from outside the material. The exam question must come inside the material. So there's no need of, I don't see the reason someone should fail this course or fail any course from outside. As a matter of fact, Mr. Director gives enough time for you to research and even for you to use your book and answer your question. Unlike in Nigeria, even like ODL will operate in Nigeria here, you cannot use your book to enter exam hall, and you cannot write the exam in your house. The kind of ODL, open and distance learning, will operate in Nigeria here. You cannot write the exam in your house. You must come to the exam hall and write. So I don't see the reason why someone should come in and here and say that he failed the course. One, the exam is extracted from the course material, and you have the course material, and you are with the course material, and you're writing the exam with the course material, and over 24 hours given to you. I think he gives 48 hours for the exam. I don't see the reason why the students should fail the exam. What is the reason of you failing the exam? Except the material is not given to you, you don't know the area, and then you are being lectured, and you're being given an opportunity to ask questions so that you'll be able to make it in your exams. So that's my final statement. Thank you.
Thank you so much, Lawyer Charles, for your closing remarks. That was very well noted, and I side with you because there are instances where you see some people trying to attend the questions, but they will not write anything actually. You just be writing the HHHGGG. Like you look at it and ask yourself, is this person really serious? You know, if for nothing at all, you are learning, you are advancing yourself. So whatever thing you do, just take it seriously. This video is going to be on all our social media platforms, for instance, YouTube and Facebook. We are going to upload it. It's recorded and it will be made available to even people who weren't able to join the session. So that is how we operate. So if you forget anything that was in the lecture orally, but in the exams, you can just refer to the audio or the video on YouTube and you are good to go. So that'll be all. Thank you all for your time. And like Charles, please, do you have any idea of when the exams is coming off? When are you going to be ready with your questions?
I might want to say the question. By God's grace, the question will be ready tomorrow. I will need the books and developing. I will do it, don't worry. The question will be ready tomorrow. It is well.
Yeah, I thought that have been the tradition for some time now, right?
No problem. I will do that. It's not a big deal.
All right,
The only thing
thank
I'll
you.
just suspend what I'm doing. I'll just do it. Thank you.
All right, thank you. Thank you so much.
Yeah.
And have a very good evening. All
Yeah.
for your time spent on this lecture. God bless you and see you another time.
And you too. Bye bye.